Yes, Mr. Gupta.
Milord, this is the WP 14145.
Yes.
Just one caveat I would like to request, Milord, your Lordship would grant me that liberty. I'm ready to argue, and I'm arguing also.
Yeah.
Resolution of the petitioner number 3, Milord, inadvertently could not be filed, which, Milord, I wish to file. And Lord, I would seek a week's time for that, but I will argue the matter today on merits. Only this resolution would be, my Lord, that this petitioner number 3, Chamber of Commerce and Industries, my Lord, represented by Chairman Tejkul Singh Pali, was authorized, and the members duly authorized him. Resolution in that regard only, my Lord, I need to follow. File. That authorization was there, but somehow, my Lord, it missed and could not be filed.
Our petition is competent without authorization.
Lord, it is, Lord, it is to be filed. Therefore, I am saying, Lord, it is necessary to be filed.
Petition to petitioner number 3. Petitioner number 1 and 2 have come in their.
Petition number 1 and 2 are individuals.
Deal with them in individual capacity. As far as petitioner number 3 is concerned,
Yes.
without bringing a resolution on record, how a petition on behalf of you withdraw petition for petitioner number 3 and may file it
Lord,
afresh.
give me 4-5 days time, my Lord. I will file it in the meantime.
5 days time cannot be granted because there is a serious objection from municipal corporation.
No, Lord, I can certainly understand. I can argue the matter, but your Lordship may not even reserve it. If it is completed today. But your Lordship may grant me 7 days time to file the resolution in the meantime, my Lord.
I'll not be in a position to grant you any time to file resolution. Your party should face the consequences for its own negligence. I can grant you liberty to withdraw for petitioner number 3 with liberty to file properly constituted petition. That I can grant you. And I'll hear this petition for petitioner number 1 and 2.
Well, I'll have to seek instructions, Lord. Therefore, I mean, only thing is.
Senior advocate to always instructed रहते हैं.
ठीक है सर, आप सुन ले मेरे मैटर को, सुन ले सर.
सुनाइए. तो फिर you are withdrawing or I have to dismiss this petition for petitioner number 3?
Lord, certainly I will then withdraw only with liberty to file a fresh.
For the petitioners at the outset, praise for withdrawal of this petition for petitioner number 3, Bhopal Chamber of Commerce and Industries, as no resolution has been placed on record duly authorizing the chairman to file this petition. Accordingly, this petition is dismissed as withdrawn.
As per the judgment of this honorable court, there are 3 requirements. First, there has to be a resolution. Second, there has to be a list of members, my lord. And thirdly, my lord, bylaws also, my lord, has to be filed. Not only on the basis.
Is dismissed as withdrawn at full stop with liberty to file fresh, properly constituted petition. Next paragraph. Shri Sanjay K. Agarwal, learned senior advocate, assisted by Shri Yashovardhan Jain, in his turn submits that 3 requirements are there. Namely, there should be a resolution. Next, there should be a copy of bylaws. And thirdly, a list of the members of the association. Full stop. Next paragraph. As far as these aspects are concerned, they can be looked into as and when a new petition is filed on behalf of petitioner number 3. Full stop. Next paragraph. With the consent, matter is taken up for final disposal for petitioner number 1 and 2. Chaliye, bataiye.
Milord, what has happened is, Milord, in Bhopal, there was a commercial license fee imposed by a municipal corporation, Milord. And that license was, Milord, your Lordship, I placed that order as an extra P1 at page 30.
P1,
Milord. This license fee is a license fee which any person, any trader, Milord, if required to conduct any business in the locality of in the territorial jurisdiction of municipal corporation, then is required to pay on a fixed basis, depending upon the kind of trade he's undertaken.
Yes.
The Lordship will just see page 30.
30, yes.
अलग-अलग किस्म के लोगों के लिए अलग-अलग था. जैसे पशु आहार, तो पशु आहार के लिए
जी
निर्माता के लिए अलग, थोक के लिए अलग, फुटकर के लिए अलग।
जी
इसी तरह ईंधन के लिए अगर आप देखेंगे तो कोयला, जलाऊ लकड़ी, गैस वितरक, गैस वितरण, ये सब अलग अलग।
जी
आभूषण के लिए अगर आप देखेंगे तो आर्टिफिशियल ज्वेलरी, सुनारी का कार्य, ज्वेलरी, मतलब डिपेंडिंग ऑन दैट, आई विल नॉट वेस्ट योर टाइम, बट ओनली थिंग इज दैट इट वाज बेस्ड ऑन द काइंड ऑफ ट्रेड दे वर अंडरटेकिंग,
जी
and this amount was fixed.
यस
No matter where are you carrying on, this was a license fee. This was for the purposes of giving license to carry out this trade.
ओके
We were not aggrieved by this. We were paying this, my lord.
राइट
What happened, my lord? In 2021, the elected, sorry, my lord, in 2020, the elected term of elected councillors and mayor, my lord, came to an end.
जी
And from 2020, my lord, the elections got delayed up to 2022.
जी
And ultimately in 2022, my lord, the elections were to be held.
जी
But the elections were not held, and in the interim period, my lord, the administrator
जी
was appointed for managing the affairs of Bhopal Municipal Corporation.
जी
So these facts are undisputed.
जी
Now, my lord, the administrator, who happens to be an IS officer, my lord, joined and passed a resolution to amend the basis on which a commercial or trade license fee shall be now charged.
जी
And that, your lordship will see, the resolution was at page 41, and the consequential standing order is at page 42.
Annexure P3
P3, my lord.
P3 yes
Now, what they have done is, my lord,
जी
instead of the kind or the trade which the person is carrying out, my lord, your lordship will just see,
जी
मध्य प्रदेश नगर पालिक निगम 1956 की धारा 132 6 ग के अंतर्गत नगर निगम सीमा में कोई भी व्यवसाय या व्यापार करने वाले व्यवसायियों पर स्थायी आदेश क्रमांक 10/2017 में आरोपित दरों को संशोधित करते हुए टाइप ऑफ रोड के आधार पर प्रशासक का संकल्प क्रमांक सो दिनांक 23/9/21 से स्वीकृत उपरांत निम्नानुसार किया जाता है।
जी
अब इन्होंने क्या कर दिया सर कि गलियों और एकल रोड पर उसकी रेट अलग कर दी, डबल रोड मुख्य रोड पर उसकी रेट अलग कर दी, 4 लेन और उसके अधिक लेन पर इसकी रेट अलग कर दी, 6 रुपए कर दी, 4, 5, 6 रुपए प्रति वर्ग फीट के हिसाब से। तो अब टैक्स जो है ट्रेड पे ना लगकर आपकी शॉप, आपकी प्रॉपर्टी पे लग रहा है
जी
कि आप अपना काम 100 स्क्वायर फुट की दुकान से कर रहे हैं या 2000 स्क्वायर फुट की दुकान से कर रहे हैं, उसके आधार पे लगेगा। और कहाँ आपकी दुकान सिचुएटेड है, वो मेन रोड पर है कि 4 लेन रोड पर है कि डबल रोड पर है कि गलियों में, इसके आधार पे लगेगा। सो दिस बिकेम नॉट वेरिएबल। Now, result of this is,
जी
Lord, if I am carrying out a shop in a market which is a smaller, situated on a smaller or a narrower road, I am charged less. And the same shop, if I am carrying on a mukhya road, then I am charged more,
जी
which we say is not correct and illegal.
जी
Then this, my lord, further was amended by P4. This is संशोधित स्थायी आदेश क्रमांक 27/2022.
जी
And now, my lord, from this, the industrial units or the people involved in industrial trade, my lord, have been taken out. और बाकियों के लिए वैसा ही रहेगा।
उनको उन्होंने फिक्स कर दिया और आपको जो है
हमको जो है अभी भी वेरिएबल रखा है,
आप कितनी चौड़ी सड़क पर बैठते हैं उसके हिसाब से कर दिया
उसके हिसाब से रहेगा
जी।
Now, my lord, after that, if your lordship will see, another amendment was made by annexure P6.
जस्ट अ मिनट, एक मिनट रुकिएगा प्लीज। जी P6 yes
P6, my lord,
जी
they brought an amendment that all industrial units are kept exempted from variable trade license P based on type of road.
जी.
So P6 has again been brought, my lord.
जी.
और अब उन्होंने रोड की चौड़ाई और वो सब लिख दिया इसके अंदर.
जी. जी.
Then, my lord, what is more important is now, please come to P7. My lord, the documents which I read to your lordships are only limited to Bhopal, P6, still P6.
जी.
Now, P7, my lord, the government of Madhya Pradesh,
जी.
by notification dated 21st April 2023,
जी.
brought uniform rules for this entire state of Madhya Pradesh.
जी.
They were called, my lord, मध्य प्रदेश नगर पालिका ब्रैकेट में व्यापार अनुज्ञापन नियम 2023.
जी.
And then, my lord, adopted similar kind of a policy that on the basis of the width of road, the license fees shall be charged.
Yes.
And if your lordship will see for that, my lord, page 51.
Page 52.
जी, पेज 52 पे टेबल लिखा हुआ है.
हाँ, टेबल बना हुआ है.
पर एवं खुले स्थान उसका 1 नंबर 2 नंबर, फिर खा है उसका का, खा है कच्ची गुमटी, कच्ची दुकान.
Are you challenging the validity of this notification?
My lord?
Are you challenging the validity of
No.
the notification?
No, why I am saying, my lord?
जी.
Because these rules were brought by the state of Madhya Pradesh, and immediately realizing that this will create havoc in the state of Madhya Pradesh, the government itself, my lord, suspended it.
Okay, where is that order?
By Annexure P8.
P8.
That is 25/4/2023 within 4 days.
Just a minute. Just a minute.
P8.
जी.
But my problem still remained because what it wrote in this order P8 is, my lord, the government, नगरीय विकास एवं आवास विभाग द्वारा मध्य प्रदेश राजपथ साधारण भाग 4 क्रमांक 16 दिनांक 21 अप्रैल 2023 में प्रदेश के नगरों की सीमा के भीतर कोई व्यापार करने के विनियमन के लिए मध्य प्रदेश नगर पालिका व्यापार अनुज्ञापन नियम 2023 अधिसूचित किए गए हैं. राज्य शासन उक्त नियम के क्रियान्वयन को एतद द्वारा तत्काल प्रभाव से आगामी आदेश तक के लिए स्थगित करता है. इन नियमों के लागू होने से पूर्व जिन नगरीय निकायों द्वारा मध्य प्रदेश नगर पालिक नियम अधिनियम 1956 अथवा नगर पालिक अधिनियम 1961 की धारा प्रावधान अनुसार इकाई स्तर पर व्यापार विनियमन के लिए व्यापार अनुज्ञप्ति ट्रेड लाइसेंस जारी करने के लिए शुल्क निर्धारित करके लागू किए गए हैं, वह पूर्व अनुसार लागू रहेंगे. So government decided uniformly to apply a similar kind of a rule, way, basis, methodology, but then suspended it and said that whatever was applicable earlier will remain in force. So my problem again goes to Lord P2, P3 and P2, P4 and P6. Because in Bhopal and none other city of Madhya Pradesh, such kind of methodology of charging license fees being made. And because of this line that जो पहले लागू थे वो चलेंगे, they have come into play again, and I'm being charged on the basis which the government itself has suspended.
Yes.
Because government also made these rules on the basis of width of roads. But government realized this is not the right methodology, it's suspended. And thinking that everywhere else, other methodologies or on their own, they must have devised some methodology, they applied that all right, old rules, old rates shall be applicable. So what we are submitting is, firstly, it is a license fee, which is made applicable in a fixed way by an annexure P1.
जी.
Fee I can understand, my lord, and your lordships have held it so many times, that fee is for some work you do. Because we are carrying out trade license, we need a license from you. We are carrying out trade, we need a license for it. And therefore, Nagar Nigam Municipal Corporation grants us license, therefore charges a fee for granting a license. That can be one kind of amount common for all, because the municipal corporation does not tax us. Now, what they do, they take help of section 132. Your
Yes,
Lordship may see 132 of Municipal Corporation Act.
yes.
Taxes to be imposed under this act. For the purpose of this act, the corporation shall, subject to any general or special order which the state government may make in this behalf, impose in the whole or any part of municipal area the following taxes. This is not relevant for us. There are taxes, various taxes,
Ji,
cess, and other things will not applicable in this. They say that they have done this into 132(6).
ji,
Subsection 6 reads like this, Lord.
ji.
In addition to the taxes specified in subsection 1, the corporation may, for the purpose of this act, subject to any general or special order which the state government may make in this behalf. Lord, I lay emphasis on these words, subject to any general or special order which the state government may make
Ji,
in this behalf.
ji.
Impose any of the following taxes, namely, A, I may leave, my lord, this is one other tax. B is now omitted. That was a drainage tax. Now C, my lord, they say that they have done it under this clause C.
Ji,
A tax on persons exercising any profession or art or carrying on any trade or calling within the city.
ji.
So what is empowered is, my lord, they can impose a tax on persons
Ji,
subject to any general or special order which the state government may make in this behalf.
ji.
F, my lord, F may also be seen because that relates to fees.
Ji.
Fees on registration of cattle.
Registration of cattle sold within. You are not a
I'm not-
cattle dealer.
Absolutely not.
You
And
may
what
be-
I'm saying,
you
no,
may
what I'm saying is, my lord,
with us, but still you are not a cattle dealer.
what I'm saying is this, my lord.
Hmm.
There are taxes defined separately, fees defined separately.
Yes.
Under the garb of 132(1)(c), 132(6)(1)(c), they are aiming at fee on us under the garb of tax.
Ji.
And for that, your lordship will again see section 133.
Just a minute. Section 133, yes.
I'm just reading it for the purpose that the act clearly will not make a distinction between a tax and a fee.
Padhiyega.
Imposition of taxes and fees.
Yes.
A corporation may, by resolution at the time of final adoption of the budget, estimate the next financial year, so and so impose any taxes or fees as specified, increase the rates of taxes or fees already imposed. So what I'm saying is tax and fee are two different things, two distinct nomenclature used differently for different purposes. What 132(6)(1)(c) empowers municipal corporation is to levy a tax, impose a tax on us,
Ji.
and not the fee.
Yes.
What was being charged to us was a fee, as it was fixed fee, one time, whenever for a whatever validity of the license was.
Yes.
Had it been 6 monthly license, then it has to be renewed every 6 months. Had it been monthly license, it has to be renewed monthly. In our case, my lord, it was a yearly license, so it was to be renewed on a yearly basis. So fixed fee for all kinds of different kinds of trades.
Yes.
Now, my lord, secondly, what I am submitting is, your lordship will see section 423. that deals with the Lord power of the administrator of the Municipal Corporation Act.
Yes.
When the corporation is dissolved under section 422, the following consequences shall ensue. Lord, the ABC, I may
Okay.
leave, and then your lordship may see that subsection 2. The
Yes.
person of the committee or persons appointed under clause B of subsection 1 shall be called the administrator of the city and may sue and may be sued in the name of the administrator of the city. The administrator of the city shall be subject to the controller of the control of the government and such other person or persons as it may direct, and shall be subject to all other restrictions, limitations, and conditions imposed by this act on the corporation and the mayor and council and the appeal committee. So he is also not subject to any special or general order made by the government. Lord, these are the provisions which are relevant in our case. Now, what is happening is, without there being an elected body in the municipal corporation,
Ji.
the commission, the administrator, Lord, increases its license fee many folds and changes the methodology of charging it. Lord, the administrator is just a time gap arrangement till the new body is elected.
Ji.
And for that, my lord, I'm just referring to one judgment. Lord, my friend Mr. Mishra will pass on a judgment to your lordship. 2000 volume 6, SCC page 127. Joint Register of Cooperative Societies Kerala versus T.A. Kuttappan and others. My lord, we'll see para 7.
Yes. Yes.
If we carefully analyze the provisions of the Act, it would be clear that the administrator or a committee appointed while the committee of the management of the society is under suppression cannot have the power to enroll new members, and such a question ought not to be decided merely by indulging in an exercise or semantics in ascertaining the meaning of expression have power to exercise all or any of the functions dash dash dash. Whether an authority is discharging a function in exercise of power or exercising a power will have to be ascertained with reference to the nature of the function or the power discharged or exercised in the background of the enactment. Often we do express that functions are discharged or powers exercised or vice versa, depending upon the context of the duty or power enjoined under the law, if the two expressions are interchangeable. What is necessary to bear in mind is the nature of function or power exercised and not the manner in which it is done. Indeed, this court, while considering the provisions of section so-and-so of Karnataka Act, which enables special officer appointed to exercise and perform all the powers and functions of the committee of the management and or any officer of the cooperative society, not merely functions, took a view that the administrator or special officer can exercise powers and functions only as may be required in the interest of the cooperative society. In that context, it was stated that he should conduct elections as enjoined under the law. That is, he is to conduct elections with the members as on the rolls, and by necessary implication, he is not vested with the power to enroll new members of the society. We may add that a cooperative society is expected to function in a democratic manner through an elected committee of the management, and the committee of the management is empowered to enroll new members. Enrollment of new members would involve alteration of the composition of the society itself, and such a power should be exercised by an elected committee rather than by an administrator or a committee appointed by the registrar. So what point I am trying to make out is this, my lord, that administrator is a time gap arrangement. He has to be there only to run the corporation.
If this court has to accept your argument that administrator is a time gap arrangement, and this judgment of T.A. Kuttappan is taken into consideration, then whether after elected body came into effect, it has superseded the resolution or the orders of the administrator.
Because they haven't passed any such order.
The issue is that if we take this argument further,
Mila.
I'm just referring to this last argument that
Yeah.
administrator had no authority to pass an order under section 132(6)
Yeah.
or that he has limitations under section 423, then whether that has been superseded by the elected body or mayor in council,
Mila, it has not been
and whether you
superseded, neither been ratified.
ratification is something different.
So it is, Mila, I bow down, Lord. I understand your lordship's point. It has not been superseded.
Yes.
Correct. Direct answer is this, that it has not been superseded to the best of my knowledge. My friend Mr. Agarwal, Milord, may inform your lordships whether it has been superseded or ratified or not, or what action has been taken by the elected committee.
Yes, yes.
And therefore, Milord, we have made the municipal corporation and commissioner, everybody party here, so that, Milord, that can be answered. But what I say is that the action which has been taken by the commission, by the administrator, during the period when he was an administrator, he could not have done this or changed the entire basis of charging the trade license fee, as it was not in the domain of the administrator. And more so, why I'm saying this is, Milord, because this methodology, when adopted by the government, Milord, and frame rules, was stayed by the government itself. Government itself is convinced now that this methodology will not work, and therefore it has suspended this methodology.
Okay.
Yes, Milord.
All right. That argument is already noted. Anything else?
Milord, there is a difference between a tax and a fee.
That you have already said.
Milord, I just give your lordships one judgment.
Ji.
Lord, Mr. Mishra, please pass on. 1954, Volume 1, SCC 412. This is Commissioner Hindu Religious Endowments, Madras versus Lakshmendra Tirth Swamiyar of Sri Shirur Mutt.
Yes.
Because by making this change in basis, Lord, the entire structure of fees changed.
Ji. Ji.
A fixed amount was required to be paid. Now they are charging in a variable way.
Yes.
Based on the type of road.
Ji.
And not on the type of trade. Lord, your lordship will note para 42, 43.
Just a minute, just a minute. Para 42.
42, 44, 45 and 50.
जी बताइए.
Para 42. So far as first ground is concerned, it is not disputed that the legislation in the present case is covered by entries 10 and 28 of list 3 in schedule 7 of the constitution. If the contribution payable under section 76 of the act is a fee, it may come in under entry 47 of the concurrent list, which deals with fees in respect of any of the matters included in that list. On the other hand, if it is a tax, as this particular tax has not been provided for in any specific entry in any of the three lists, it could come only under entry 97 of the list, 1 or article 248(1) of the constitution, and either in view of the union so and similar, then Lord may see para 44. A neat definition of what tax means has been given by Latham CJ on the High Court of Australia and so and so. A tax, according to the London Chief Justice, is a compulsory exaction of money by public authority for public purposes enforceable by law and is not payment for services rendered. This definition brings out, in our opinion, an essential characteristics of a tax as distinguished from other forms of imposition, which in a general sense are included within it. It is said that the essence of taxation is compulsion. That is to say, it is imposed under statutory power without the taxpayer's consent, and the payment is enforced by law. The second characteristics of tax is that it is an imposition made for public purpose without reference to any special benefit to be conferred on the payer of the tax. This is expressed by saying that a levy of tax is for the purpose of general revenue, which when collected forms parts of public revenues of the state. As the object of tax is not to confer any special benefit upon any particular individual, there is, as it is said, no element of quid pro quo between the taxpayer and the public authority. Another feature of taxation is that it is a part of a common burden. That quantum of imposition upon the taxpayer depends generally upon his capacity to pay. Coming to fees, para 45, coming now to fees, a fee is generally defined to be a charge for a special service rendered to individuals by some governmental agency. The amount of fee levied is supposed to be based on the expenses incurred by the government in rendering these services. In our case, it is a fees. Though in many cases, the costs are arbitrarily assessed. Ordinarily, the fees are uniform and no account is taken of the varying abilities of a different recipient to pay. These are undoubtedly some of the general characteristics, but as there may be various kinds of fees, it is not possible to formulate a definition that would be applicable to all the cases. As regards the distinction, then Lord may another discussion, and then ultimately Lord and para 50. Sorry, 48 also Lord may be seen. In other cases, class of cases, the government does some positive work for the benefit of the person, and the money is taken as a return for the work done or services rendered. If the money thus paid is set apart and appropriated specifically for the performance of such work and is not merged in the public revenues for the benefit of general public, it could be counted as a fees and not a tax. There is really no generic difference between the tax and the fees, as said by Seligman. The taxing power of state may manifest itself in three different forms, known respectively as special assessments, fees, and taxes. So what I am saying is, Lord, 132 gives them 1C gives them power to impose a tax. But there's no power given to impose a license fee for giving us license to set up a trade in their territory.
Yes.
Taxation can be on the basis of turnovers, but can't be on the basis of the location of the property where the person is carrying out a trade.
Yes.
So either it has to be static, that the kind of trade you're carrying on, wherever you're carrying on, a static fee will be charged from you for granting license, which was done by an extra P1, but can't be variable. Then Lord, one judgment of Supreme Court, Lord, another, Mr. Mishra, please pass on, 2005, Volume 4, SCC 245, Calcutta Municipal Corporation versus Shrey Mercantile. This is 2005, Volume 4, SCC 245, Calcutta Municipal Corporation. Lord, we'll see para 1, the question framed before the Supreme Court was, the short question which arises for determination in these civil appeals by grant of special leave by Calcutta Municipal Corporation is whether
You are referring to para 11.
Para 1, my Lord.
Para 1.
Para 1. The short question which arises for determination in these civil appeals by grant of special leave by Calcutta Municipal Corporation is whether the imposition of process of change in the name of the owner in the assessment books of corporation is in the nature of a fee or a tax. Then your Lordship will see para 7, para 21.
Yes.
That is at page 262.
Yes.
Last but one. Now coming to the question of challenge to the levy as arbitrary and discriminatory and violative of Article 14, we find that the functions of the corporation with regard to mutation remain the same. Whether the applicant is a transferee under a conveyance or a lessee or a beneficiary under a will or an heir in the case of intestate succession. Once an application for mutation is made, the same is examined by the department, and after hearing the objections, if any, the record is ordered to be changed. Ultimately, the exercise is for fiscal purpose. Similarly, the property valuation may be below rupees 50,000 or above rupees 2 lakhs. The function of the corporation in making the mutation entry remains the same. So this is my point, my lord. Whether a person is carrying out a trade on a main market or a main road or in a small gully is immaterial.
Yes.
Because your job is to grant him license.
Yes.
Whether that trade can be permitted to be carried out or not is the object of license fee or a grant of license. Similarly, the property valuation may be below 50,000 or above rupees 12 lakhs. The function of the corporation in making the mutation entry remains the same. Similarly, whatever may be the cause of mutation, whether it's a case of transfer or devolution or an activity of mutation, the activity of mutation remains constant in all the cases. The expenses incurred in all the cases also cannot vary. Whatever be the value of the property or the cause of mutation, in the circumstances, there is no reason given for charging different rates depending upon the value of property and cause of transfer. Here also, my lord, the respondents have not come up with any explanation as to what is their basis of charging on the basis of location of the property at different roads.
Yeah.
In the circumstances, there is no reason given for charging different rates depending on the value of the property and the cause of transfer. By doing so, the incidence of levy falls differently on persons similarly situated, resulting in violation of Article 14 of the Constitution. Lord, the examples have been given in the reply that if a garment shop is situated in a smaller road and a garment, similar kind of a garment shop is situated on a main road, then they earn differently, their location is different, the trade is different. So this is what is what Supreme Court says, that this, by doing so, the incidence of levy falls differently on persons similarly situated. I can understand, my lord, in a market, one person doing more business, depending, evaluating it from its turnover, is charged. But here, they are only giving us license to carry out a trade. So they can only charge a fee. And that could be static as it was in Annexure P1. That's what my case is. Then, my lord, one judgment of Madhya Pradesh High Court, my lord, Gwalior bench, division bench, my lord, Mr. Mishra, Fun Multiplex Private Limited versus State of Madhya Pradesh, 2012, Volume 2, MPSJ, page 134. Fun Multiplex Private Limited. 2012, Volume 2, MPLJ 134. Lord, here was a case where, my lord, cinema halls were running in the city of Gwalior. Lord, the charge per show was rupees 50 per show per screen, which municipal corporation, my lord, increased to 500 rupees per screen per show. And this was challenged, my lord, before the Gwalior bench. And it was also a case of section 132(6) of the Municipal Corporation Act 1956. Lord, detailed discussion is there, but the point which I am trying to bring is, my lord, from para 8. From perusal of subsection 6 of section 132 of the Act of 1956, it is clear that the corporation can impose any tax mentioned in the aforesaid section, subject to any general and special order which the state government make in this behalf. From the aforesaid section, it is clear that the power of corporation to impose tax is subject to rider prescribed in section 132, subsection 6 of the Act of 1956. It means that it is necessary for the corporation to get prior permission of the government before enhancing the tax from rupees 50 to 500 per show per screen. Admittedly, no such permission has been taken by the corporation in this behalf. Earlier, the corporation had power to impose show tax at a maximum of rupees 200 per show per screen. Para 9, hence in our opinion, enhancement of show tax by the corporation is without prior permission of the state government, is without power and authority. In our case also, my lord, this methodology which the administrator changed has no sanction or permission or approval from the state government. So by virtue of, my lord, this judgment, this enhancement is purely without authority. Then my lord will see one judgment is 1961 SCC Online Allahabad, page 202. Durga Das Bhattacharya versus Municipal Board. 202. 1961 SCC Online Allahabad, 202.
जी.
Lord, we'll see para 7 first.
Yes.
The nature of a license fee. Now I'm dealing straight away with the license fee. The nature of a license fee has been described by Robert J. So and so and so and so in the following words. Whatever a state may forbid or regulate, it may permit upon condition that a fee be paid in return for the privilege. So it is a fee which is being charged for allowing a trader to carry on his trade.
Okay.
And such a fee may be exacted to discourage the prosecution of a business or to adjust competitive or economic inequalities. Taxation may be made the implement of the exercise of the state's police power. Then, my lord, para number 62, my lord, last one page.
Yes.
In Hingir Rampur vs. Coal Company Limited versus State of Orissa, judgment, it was held that when the legislature levies a fee for rendering specific services to a specified area or class of person or trade or business, in the last analysis, such services may indirectly form part of services to the public in general. If the special service rendered is distinctly and primarily meant for the benefit of a specified class or area of the area, the state as a whole may ultimately and indirectly be benefited, would not detract from the character of the levy as a fee. Where, however, the specific service is indistinguishable from the public service and in a sense is directly part of it, different consideration may arise. In the present case, the board is spending money over paving of lanes and streets and in lighting them and is only rendering service to the general public for performing a statutory duty and no special service to the licensees. If these two items are excluded from consideration, the total of the remaining two items would not justify the realization of as big a sum as rupees 1,25,000. For these reasons, I am of the opinion that the impugned fee is ultra vires the respondent. Now, Municipal Corporation does not incur any different expenditure on the trades differently or not in the exercise of granting license based on the road. Their process remains the same, no matter where the trade is situated, where the shop is situated, whether it's on a main road or on a small road or still a gully. The process of Municipal Corporation of granting license remains the same. Therefore, I'm submitting that administrator was in time gap arrangement. He could not have enhanced or changed the methodology. Number two, when the state government itself adopting this methodology has kept it in abeyance for entire state, then this is discrimination for Bhopal. Because in Bhopal, this methodology which the state adopted by making rules, that is license fee to be calculated on the basis of the location or on the location of a shop or a trade situated on a different road, has been kept in abeyance by themselves. Though state government has not filed any reply, but what I am submitting is, my lord, once this kind of methodology, once adopted by the state, kept in abeyance for the rest of the state, then, my lord, only on the basis that since the line is used that the earlier methodology, wherever adopted, may be continued, my lord, this is causing discrimination for the Bhopal, my lord, and rest of the cities, Indore, Gwalior, Jabalpur, Rewa, all other cities, my lord, wherever the corporations are, my lord, they are enjoying benefits, and the people of traders of Bhopal are, my lord, deprived. It was for this reason, my lord, we wanted to bring it as a representative capacity through the Chamber of Commerce. But whatever, my lord, for technical reason, I will raise that issue somewhere else. But these two, one petitioner and petitioner two, my lord, still
Yes.
press their point.
Yes.
And we submit, my lord. Now, one
Sir.
more thing, my lord. Just one more thing, my lord.
Ji.
Before my friend Mr. Agarwal starts, my lord. Mr. Agarwal has raised a point in the reply saying, my lord, that there is an alternative remedy in terms of section 421 of the Municipal Corporation Act. Like, I would like to read section 421 to say that this is a inter se mechanism, and they have also, my lord, used the word inter se mechanism in their reply between the corporation and the state. Outsiders are not involved in this.
Let us read that 421.
Milord, in reply, they have taken this point in paragraph number.
That is not relevant. Let us come
Very
to
well,
section
very well,
421.
very well. In paragraph number 10 of the reply. Milord, power of government to suspend any resolution or order. If the government is of the opinion that execution of any resolution or order of the corporation or any other authority or officer subordinate thereto, or the doing of any act which is about to be done or is being done or by or on behalf of the corporation is not in conformity with law or with the rules or bylaws made thereunder, or is likely to lead to a breach of the peace or to cause injury or annoyance to the public or to any class or body or persons, or is likely to cause waste of or damage to municipal funds, the government may, by order in writing, suspend the execution of such resolution or order or prohibit the doing of any such act. 2. Copy of such order shall be sent to the corporation by the government. Number 3. On receipt of copy of the order as aforesaid, the corporation may, if it is of opinion that the resolution and order or act is not in contravention or excess of powers conferred by any law for the timing in force, or the execution of the resolution or the doing of an act is not likely to cause wastage of or damage to the municipal fund, make a representation to the government against the said order. The government may, after considering the said representation, either cancel, modify, or confirm the order passed by it under subsection 1, or take such other action in respect of matter as may, in the opinion of the government, be just or expedient, having regard to all the circumstances of the case. Nowhere, my lord, a third party is involved or given any power to invoke section 421. It is somewhat suo motu power of the government that if it comes to know that some order is passed by some corporation, some resolution, then government may do so. And if government does it, then corporation has the chance to make a representation against that order. So it is an inter se between the government and the municipal corporation. The person affected is not there. In a way, my lord, in a way, what I submit is, if the objection is to be understood, my lord, or section 422(1) is to be understood, in my way, my lord, it is that the government took note of making a uniform rule for the entire state based on the location of roads, and realized within 3 days that this is going to create havoc and suspended it. So government's view is not to implement or charge license fee on the basis of location of roads. In a way, my lord, this 421 is in the shape of invocation, making of rules and then suspending it.
Yes.
They are just taking advantage of a general line noted there in that order P8. I read to your lordship, that whatever was earlier being charged, that can continue. I don't think government may have realized that in Bhopal, this the method